This is based on an incident that occurred on October 14, 2019. I'm sorry. The defendant was indicted on October 14, 2019 for first-degree murder. He was found guilty on May 3rd, 2022 of second-degree murder by a jury trial. It's based on an incident that occurred on June 10, 2019 around 10 p.m. in Dyersburg at the vicinity of 219 Liberty Street in Dyersburg, which is a residence. The allegations are that the alleged victim, Mr. DeMarco Robertson, was standing in front of that residence with a group of other individuals that night. It appears that there were some kind of get-together. There was alcohol there and numerous folks there. And that my client, Mr. Livingston, and two other individuals, Taylor Kennedy and Jordan Bell, were in a vehicle that passed by the residence. Miss Bell was driving. Miss Kennedy is in the front passenger seat, and my client, Mr. Livingston, is in the back. And the allegations are that that gunfire was exchanged. That Mr. Livingston fired a weapon, and that there was a weapon fired by someone located at the 219 Liberty address as well. Mr. Robertson died of gunshot wounds.
Mr. Dunn, as I understand the sufficiency argument, at least in part, you assert that there should have been a self-defense instruction?
Yes, there was a self-defense instruction, Your Honor. And
that's right. How is self-defense actually raised by the proof?
Your Honor, and that is why I wish to come before the court, and
right.
And is the particular reason I wanted to come today is that first and foremost, I think Miss Bell, in her testimony, if I may, Your Honor, I think as clearly as anyone indicated what happened that night as far as the shooting. And I'm going to summarize her testimony. When this occurred, Mr. Livingston had asked if a T-something was there. He got no response from Miss Bell or Miss Kennedy. Once they make it past the crowd, she referred to as a crowd, she hears a shot. And at that time, they were going slow. After she heard the shot, then Mr. Livingston said something to the effect, "It jammed, go, 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 they are shooting." Then she took off and she could hear gunfire.
But didn't Miss Bell also testify that the defendant told her where to drive?
Yes, sir.
And asked her specifically to point out a person in the crowd?
Yes, that is correct, Your Honor.
That seems to be inconsistent with self-defense. Would you concede that?
I would agree that does fit in with the state's case. It does support the state's case of the second-degree murder charge. What I would reply to that is that what the state was trying to prove by saying that, and saying that he was pointing out where to go, and other allegations made by the state asking about if certain persons there, is that he was the one out looking for trouble that night. Well,
the state says it was a targeted assassination.
That's not, yes, Your Honor, that is not, I don't believe that's in the, I don't believe the proof would support that kind of allegation, targeted assassination.
Well, the thing was, the jury didn't find that. They found murder second degree, which is an intentional killing.
Yes, Your Honor.
And again, we go down to, ultimately, the jury heard this evidence. They heard the proof. They got a self-defense instruction. They heard that someone else out there was shooting too. They heard all this, and they resolved it by finding that your client was guilty of a lesser, murder second degree, the intentional killing of another person, and rejected the lessers of voluntary, and they accepted, or they considered self-defense and rejected it. So that was done by the fact finder. And so that kind of puts us in a situation where, we have to accept the verdict unless it is just completely contrary to the proof.
Yes, Your Honor. Yes, we are arguing that this was not a rational verdict. Yes, I agree. And the reason I come before Your Honors with this is because there's proof in the record that someone from that crowd fired shots. Mm-hmm. So we have that. Bullet holes in the car, a bullet found in the car Mr. Livingston was in. And we refer, like I said, indicated that the state's basically trying to show that Mr. Livingston was out looking for trouble. Well, I would point out what was going on at that home at 219 Liberty. Multiple individuals there, alcohol present. Mr. Robertson was on methamphetamine. And apparently, all this happened very, very quickly. Apparently, someone there brandished and fired a weapon very, very quickly. I would argue that they were looking for trouble there. It appears they were looking for trouble there as well.
But, so, I think both Judge Greenholz and Judge Campbell are trying to make the point that all the things you're talking about, the jury heard. And including, as Judge Greenholz points out, that, the defendant told the driver to drive to a specific location, asked the driver, show me so-and-so. The defendant fired a weapon at that person. Yes, you have what you're talking about as well, that, maybe someone fired first from the crowd as opposed to the car, and there's a bullet hole in the car. But as Judge Campbell points out, the jury weighed all this and looked at all this. And, they didn't give the state everything they wanted because they didn't come back with first-degree murder, but they did come back with second-degree murder, and they didn't feel self-defense was present. What are we supposed to do? I mean, the law's pretty clear. Our hands are kind of tied unless it just doesn't fit. And it seems to fit. We may not like it, but it seems to fit.
Well, Your Honor, I understand. And I would just go back to what I've talked about, mentioned about the gunfire coming from those folks. And also, where was the other, if this was self-defense, obviously my client and the folks in the car were shot at. So if it was self-defense on the side of the folks at 219 Liberty, where's that gun? Where are the witnesses taught?
Was that question asked at trial, so to speak? It may have been in an argument, but was that question asked at trial in front of the jury?
Well, it was argued before the jury.
The jury obviously wasn't very concerned about it.
Well,
how about this, Mr. Martin? So as I understood, the reason the trial court charged self-defense was because the trial court said, I don't know who shot first. And so out of an abundance of caution, I'm going to charge the jury with a self-defense instruction. That, as I understood the record itself. At the end of the day, though, when I review the record, I see no evidence at all that the people on the street were the parties that fired first. And I do see evidence that Mr. Livingston was the one who fired first. Is there any evidence in the record at all that would support the notion that Mr. Livingston was acting in self-defense because someone had already fired a weapon at him?
I think, based on the evidence in the record, it's not entirely clear based on my reading of the record that Mr. Livingston fired first. And it's certainly...
Is there any evidence, though, that supports an argument that someone else fired first? Is there any evidence?
Well, I'm sorry, you're right. Well, it's the state has the burden of proof of disproving, of showing that Mr. Livingston did not act in self-defense. So they would have had to prove that he was not acting in self-defense. And that's why I go back to, there's no...
I think I agree with you, and that's the source of the question.
Mm-hmm.
If the state has the burden, if the defense is properly raised, the state has the burden of disproving the existence of the defense beyond a reasonable doubt. It matters in my mind, given the deferential standard of review that we have, if there is any proof at all in the record that someone else fired the first shot. Is there any proof at all that someone else fired the first shot? Or was that a question to be resolved by the jury then? first, do we have any evidence here that would support the notion that someone other than Mr. Livingston fired first? We have speculation, but is there anything in the record?
Well, other than the fact that we know that there were shots fired, there were shots fired at Mr. Livingston's vehicle.
Which doesn't tell us anything about timing.
Yes, Your Honor, and I would also add that both of Miss Bell and Miss Kennedy, neither of them. It was mostly based on Miss Bell's testimony because the gunfire woke up Miss Kennedy. She really didn't know what was going on. Miss Bell, she did not see, based on my reading of the record, she did not see anyone firing, anyone shooting. This was based on her hearing, okay? So we have no testimony about, anybody seeing with their eyes who fired first, who fired first, who was, and then who was shooting back. It's based on Miss Bell, largely based on Miss Bell's testimony about what she heard. Now, based on what I indicated, Your Honor, and the reason I've come before the court on this particular issue, is because, like I said, that her their vehicle's being shot at. We don't have any eyewitnesses who saw anybody shooting, and there are no like I said, there are no eyewitnesses to see anyone shooting, and we know that Mr. DeMarco or Mr. Robertson's on methamphetamine as well, or he's on drugs as well. And as far also, talk about the shell casings. There were 5 shell casings found. Sergeant Logan Abbott found 4 shell casings at the scene, and one of those shell casings was found after Mr. Robertson's body was removed, and it was either found underneath it or very close to it. Okay, and also there was a spent shell casing found in the car. Now, the firearms expert indicated that he examined there's 5 shell casings. He indicated that 2 came from the same gun and 3 came from the same gun. So the reason I bring that up is that the shell casing that was found very close to Mr. Robertson could have, based on the testimony of the firearms expert, could have come from a different weapon than was fired by Mr. Robertson.
Well, let's just say you concede that there were 2 different weapons being fired. Your clients and someone on the street are firing. It goes back to, I think what we're saying is, it doesn't establish that they fired first. The Miss Bell's testimony was, she hears this gunshot. Obviously, in the car, she heard it. It was loud. And then your client says, "Oh, my gun jammed." And then they're driving. They drive off, and you have a situation where shots are being fired at the car. It doesn't get around, and it doesn't establish that these people on the street shot first. I mean, the judge, out of an abundance of caution, gave the self-defense charge to the jury. But going back to what Judge Greenhalgh said, there's nothing really in the proof that shows that these people out on the street fired first.
I understand, Your Honor, and I go back to the fact that there's no testimony. All of these witnesses,
they didn't really want to cooperate.
All these witnesses, why not, Your Honor? That would be my question. Is that
I just guess after doing this for so many years, it's not uncommon for But the big joke was everybody's in the bathroom when there's a shooting in a bar. I mean, it's just nobody wants to cooperate, and that's kind of part and parcel of this. But we do have the testimony we have is what we have.
Yeah, yes, Your Honor. Yes, Your Honor. And why all of these folks there, if this was self-defense on the side of all the folks there, or whoever was going on there at 219 Liberty, where, one witness to a witness, the gun, where's the gun? I understand the dynamic, but the state has the burden of proving that this was not self-defense. The state has the burden.
Go ahead.
I was going to actually transition to a different subject.
Okay,
think
you're
time's
eating
up.
into your rebuttal
sorry.
time, but we'll forgive it and let Judge Greenholz ask his question.
Judge, thank you very much. I know we're not here to discuss the sentencing issues, but there is a question that I have, actually, with respect to consecutive sentencing. My understanding is that the trial court imposed consecutive sentences based upon the fact that the defendant was on probation at the time the offense was committed. Was that the reason the trial court imposed consecutive sentences?
Yes, Your Honor.
Then I understand your argument to be there's no proof in the record that he was on probation at the time. What do you make of the concession of a probation violation? It seems to me that you all conceded that he violated his probation through the commission of the new offense. Isn't that pretty good evidence that he was on probation at the time?
I understand the argument, Your Honor, and the state in their briefing indicated that I think they saw the same issue I did and said, well, you know, if that's the case, then they'll let the Department of Corrections hash it out. If he, you know, if he's completed that sentence, he's completed, and that'll be done, and it won't be an issue. And
What's there for us to decide then with respect to consecutive sentences? What is it that you wish, what kind of order do you wish to come from this court then with respect to consecutive sentences?
well, well, I would ask the court to find that there should not be a consecutive sentence based on Mr. Livingston being on probation.
Despite the fact that Mr. Livingston agreed that he violated his probation through the commission of the new criminal conduct?
I understand, yes, Your Honor. I understand the
Fair enough.
argument. And I would add also, we're asking for a not guilty as to the sufficiency of the evidence and as to the facts introduced into evidence in the closing that had not been admitted into evidence, that there be a new trial based on that argument. Thank you, Your Honor.
We'll give you 2 minutes for rebuttal.
Thank you, Judge, thank you.
General Cherry.
May it please the court, Brent Cherry for the state. Good morning, Your Honors. I'm almost inclined to just ask if you have any questions. I think you've pretty much gone into the sufficiency in depth, but let me just go through it some more.
I've got a question for you since you're going to throw it back to us.
That's fair enough,
Not
Your
always
Honor.
a smart decision.
So, General, help me with this. Minor point. Consideration of deterrence as an enhancement factor. You cite a 2020 case from this court seeming to approve of the use of a non-enumerated enhancement factor, deterrence. That case cites back to a 1984 case. Is it proper to consider deterrence as a non-enumerated enhancement factor after the 1989 Act passes?
Told you that wasn't a smart strategy on your part, Mr. Cherry.
Well, Your
Well, I
Honor,
mean,
I think that question would have come up anyway, so.
I mean, I think the answer to it, my guess is from the state's perspective, is that it doesn't matter at the end of the day because the sentence is in accordance with the principles of sentencing. And so the trial court, as long as the length of the sentence is in accordance with the principles of sentencing, then all's fair.
And as I pointed out in my brief,
But-
Your Honor, there are plenty of reasons
Right.
to enhance this sentence.
Okay. But as a technical matter, is deterrence a proper consideration as an unenumerated enhancement factor?
Well, Your Honor, you know, we see this from time to time in the cases where the state brings up, you know, we've got problems in our county, and this is and I think that's a fair argument to make.
For alternative
Is it?
sentencing, yes. For alternative sentencing, yes, but it's
Right.
an enhancement factor in terms of the length of the sentence within a range.
Well, Your Honor, I don't think that, I mean, if it's not in that list of factors, in all honesty, just to be frank with the court, it probably shouldn't be considered in that perspective. Now, is it improper? Is it really wrong in the sense of fairness in what the court's considering? Because every court is going to consider, what is this community that I'm trying to defend and protect by sending somebody off to prison? So I don't think it's necessarily wrong for a court to consider that, even though it's not enumerated. But if we want to get down
Is
to
the
this,
state arguing that the trial court can consider unenumerated enhancement factors?
I think it should be able to, Your Honor, just from a common sense perspective, but it has not been enumerated. So if we want to get down to the nitty gritty of what's laid out in the statute, it doesn't fit into the statute as
Do you
far as
concede that
enhancement.
factor 16 was misapplied? You seem to in your brief.
Well, there's not, basically, when they talk about the juvenile conviction, it's mentioned, it's not explained exactly what the conviction was. Would it really have been, a felony offense if it had been? Don't know. It's just not in the record to be able to examine it. So, yes, I would concede that was not properly explored to be a basis for enhancement. But again, we have several other enhancement factors that were, and so.
Judge, thank you. Thank you.
As far as the sufficiency of the evidence is concerned, which has been raised primarily today, the evidence is clearly sufficient here. We have two women that were in the car with the defendant. One of them was a little bit out of it. She woke up to hear gunfire, and she saw the defendant hanging out the window shooting. Now, right there, let's talk about that for just a second in terms of self-defense. Somebody's shooting at me as I'm driving down the road. Am I going to grab my gun and hang out the window? Hey, let's give these guys a little bit better target because we just want to play fair. That's just simply not going to happen. The fact that the defendant is telling the driver, take this street, go down that street. Okay, do you see T, she said T something, she didn't know exactly what it said. Do you see T something in the crowd? Well, that suggests strongly that this guy is looking for somebody and he wants to shoot at him, or he wants to shoot them. Now, whether the actual victim of this case was the T something he was shooting at, and I spent some time thinking about why didn't the court come back with first degree in this case? And we can only guess about why they didn't. But it could very possibly be that maybe it wasn't T something. We don't know who he was shooting at, but he was shooting, and he should have known better. It was an intentional shooting, and he hit somebody and killed him. Maybe that was enough for them to get back off the premeditation. Don't know for sure. But it certainly was an intentional shooting. He certainly was there on his own volition. And Jordan Bell testified, I heard shots. He said, oh, my gun jammed. And then she heard the return gunfire. Now, the other evidence, it connects with this. It supports this because there were two empty shell casings that matched. That were found, that were shot from the same gun. One was inside the car. The other one was found at the scene of the shooting. And there was a live round found on the floor. What does that suggest? Well, I don't know how well versed the court is on handling handgun semi-automatic pistols and clearing jams. But once that bullet is caught in the chamber, trying to clear it, it's going to fall someplace, and it fell on the floor in this case. So that all jives with the testimony of Jordan Bell. And then we follow up with, okay, let's drive out here. We're gonna get rid of this gun. We're gonna burn some clothes, and then we're gonna head out of town. This is all evidence of guilt, and the jury was properly instructed on that. So there's plenty of evidence to support the verdict of second-degree murder in this case.
Let me turn back towards the sentencing question, though, about the probation and whether or not he was on probation. And I understand Judge Greenholt's question that if he conceded that this conviction was a violation of probation, but what if, as I kind of understand the defense's argument, they're like, I don't know if my sentence had expired or not, but if it hadn't, then this is a violation. If that's the case, what kind of finding did the trial court make to assure itself that, yes, he was actually on probation, and yes, when he committed this offense, as opposed to, I don't know, the timing may be a day or two off, I may actually have completed my sentence, and the trial judge says, well, just because you said you were on probation, I mean, is that enough, or does the trial court actually have to make that finding, I guess is my question. Because that's how I understand it. I have not obviously read the sentencing transcript, but that's kind of how I understand it unfolded is, I'm not sure my sentence expired or not, but if it hadn't, then yeah, I was on probation.
Well, Your Honor, as far as the probation for the previous sentence is concerned, we don't have really hardly anything in the record that talks about it, except for the fact that the defendant conceded, hey, yeah, there's plenty here to revoke my probation, suggesting that there was something to be revoked, that he was on probation at the time, but we don't have the details about what that was. But the reason it doesn't matter in this case is because if he was on probation and that sentence was still running, then it was certainly proper to have this sentence run consecutive to it. If that sentence had expired by the time we get to sentencing, then there's nothing for the new sentence to run consecutive to it, and it's running at this point going forward.
What about pretrial credits? So he's in custody during the entire time he's waiting a trial. And so if the sentences are running concurrently during that pretrial time, he's getting credit on both. But if they're running consecutively, he's not getting credit on both. And so he's actually serving a longer time with that if he was not on probation. So what do you make of the pretrial credit? I mean, there actually is an injury here if he was not on probation.
Well, Your Honor, again, I mean, the Department of Corrections is going to iron this all out and figure out, when does one sentence end and when does a new sentence begin? And if this sentence was running from the previous conviction, then he shouldn't be getting dual credit. He shouldn't be getting concurrent sentencing when a consecutive sentence was ordered, and that would have been proper by the court. But as far as the precise numbers are concerned, the Department of Correction will figure that out and take appropriate action.
So it's just a TDOC issue at this point?
Yes, sir. Yes, Your Honor.
Okay.
I see some heavy
Well,
thinking.
I'm trying to remember, going back through reading this, was there a violation of probation filed?
We don't even have, we don't know, Your Honor. That's just not in the record.
Okay, because if it hadn't been filed, it was running regardless. The arrest wouldn't stop the running of the probation unless there's a violation filed. And that's what I didn't remember seeing anything about whether one had been filed or not. So his probation was running the whole time that he was in custody. I just was trying to get a clarification on that, and I don't remember seeing any indication that there was a violation filed.
And it's interesting that you put it in those terms, Your Honor, because if that's the case, that would certainly have been to the defendant's advantage to have that sentence continuing to run while he was in pretrial confinement. He is actually getting double credit at that point. And if we keep going, we finally get to the sentencing hearing, and everything is done, it's to his advantage.
I guess my concern is, and you kind of actually raised it even more with that statement you just made of he's getting double credit. That is, to me, a red flag that at some point in time we're getting ready to see a habeas because they've miscalculated credits, they ran something consecutive they weren't supposed to, this, that, and the other. And so I guess my point is, isn't it more efficient for us to get it right now than us to just say, that's the Department of Corrections issue, we'll figure it out later?
Well, you certainly could, Your Honor. I mean, would it be appropriate to send this back to the trial court and say, hey, let's figure out what's happening as far as his probation is concerned, and let's fix the record? That's a relatively easy fix, and it would not necessarily be improper or inappropriate to do that, but at the same time, where we have the situation we have and the sentences are running, the court has ordered this to be consecutive.
Why would you remand the sentence instead of just saying that the sentencing decision wasn't supported by the record?
Well, Your Honor, if you want to say that the sentence is not supported by the record, aren't you essentially kicking it back for a resentencing?
We get to know that.
Or you can sentence him right here today. But if we're really going to consider that, is it more appropriate for the trial court to consider, what that sentence is? I mean, how is this court going to determine this without more evidence being put into the record to determine what was happening with that probation?
And there has to be evidence in the record to support the sentencing court's determination.
Exactly, Your Honor. In order to get that into the record, you send it back.
Well, but, okay, so on that point, whose job is it to put it in the record? It was the state's, and you didn't put it in the record. So why should we give the state the second bite at the apple of imposing consecutive sentences when they didn't do their job in the front end?
Well, Your Honor, if as far as trying to put the record together in what the probation or what the prior sentence was when it expired, I suppose that in one respect, the court does want to get all the record keeping correct. And if you're concerned about a habeas coming up at some point in the future, We have seen cases where a defendant raises a habeas issue and it works to his detriment.
True.
And this would be one of those cases if this is to be raised, if it can be proven, if it's, I mean, what's the alternative? I mean, what would this court want to do? I mean, if we're talking about resentencing today, declare that there is no proper consecutive sentence, the court could do that. And does it really matter? Does it really impact on the case? If the court had not ordered consecutive sentencing, what would be the impact? And I suppose, you know, in that respect, it becomes a big so what.
So the state wouldn't object to us ordering concurrent sentencing then to make sure that all appropriate pretrial credits are raised?
You know, just to avoid any future issues that might be raised in a habeas case, I don't think there's any objection from the state.
Because right now, we don't have, I just don't think we have anything in the record that I can see that answers the question to the point where we can really understand what happened. Going back what Judge Dyer said is that, you know, this opens it up down the road if things aren't corrected at this point to possible habeas or other types of relief to get these sentencing credits, you know, properly calculated. And
Well, and the only thing I would continue to hang my hat on, Your Honor, is that, you know, if he does have a sentence that's you know, that he has probation that's continuing, that nothing has been filed, and his probation continues to run, is that necessarily improper?
well, it could be moot by the time of sentencing, but, you know, we don't know that. But if there was never an order violating his probation, then it expired.
Right.
And I can't tell from the record whether the judge ever, or if this was the same judge who had the case, whether that case was ever terminated.
And again, Your Honor, if it did expire, then this sentence is running consecutive to a case
Well, it's a
whose
moot
sentence
point.
has already expired,
It's a
so
moot
it is a non-issue.
I think your concession is helpful, though.
Yeah.
In any event, the state would encourage the court to affirm the judgment of the trial court, perhaps with the exception of the consecutive sentencing issue.
Thank you, General. You got 2 minutes.
I have nothing further, Your Honor. Thank you.
Thank you.
Mr. Counsel, can I ask you a question then on rebuttal quickly? We didn't touch on this initially, but if we were to go back to the state's closing argument, what is it that you wish this court to do on the closing argument? Because you raised 3 issues, 2 of which had an objection, and the trial court sustained the objection on 2 of them. What kind of order do you wish to have from this court then with respect to those 2 issues?
New trial, Your Honor. I believe that's the
Even though
remedy.
The objection was sustained, the objection was made and it was sustained, you want a new trial?
Yes, Your Honor. You know, yes. In the brief, I believe I mentioned that there was no curative instruction given on those, and
None was requested.
that is correct, Your Honor. That's correct.
All right, but that's the only thing I wish to know, counsel. Thank you.
Yes, I believe that would be the appropriate relief in that matter, Your Honor. Thank you.
I'm sorry, Judge. Thank you.
No, thank you.